Buckle up, guys. Today we're stepping into Judge Shackelford's courtroom. Well, a fill-in judge who sounds almost exactly like him. The case of People versus Alyssa Hall begins, and what should have been a quick, standard arraignment instantly takes a curious turn. The judge starts with routine questions about Alyssa's identity and her understanding of her rights. But beneath her calm tone, there's a hint of confusion. It feels like she's following along but not quite getting it. As the judge continues explaining bond details, that confusion grows, setting the stage for what's about to become a tense exchange. This opening perfectly captures the calm before the storm, and you can tell, this won't be an ordinary day in court.
Calling case 251851 People versus Alyssa Hall.
Morning, Your Honor. Deputy Canton may have Ms. Hall waive formal reading, stand mute, request matter be set for settlement conference and discovery order to enter.
Ms. Hall, can you state your name for me, please?
Alyssa Hall?
Did you go through your advice of rights with your attorney, Ms. Hall?
I did.
Okay, did you have any questions about your constitutional rights?
No,
And did you allow him to sign your name to your advice of rights?
I did.
Okay, and so in front of me I have an order for discovery. I will have that signed. We're going to be adjourning this for a settlement conference for your attorney to get the discovery or all the evidence that the other side has. For purposes of arraignment, I'll enter a not guilty plea. Ms. Hall, you're going to have some bond conditions. You're to appear in court as directed. You have a $1,000 personal bond. I think I missed that. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any crimes while released. And you're to immediately notify the court of any change of address or phone number. Give me just 1 second.
I do have a question on that. My bond was returned to me.
You don't have to post any money.
Well, I know that, but I thought all bond conditions were done because the bond was returned.
Well, Ms. Hall, we're doing the arraignment now, which is we hadn't done before. So she's going to give you the bond conditions, but the bond, the monetary bond is personal, means you don't have to post any money.
But you still have to adhere to the bond conditions I just stated. Do you understand? Yes or no? Do you understand, or do you need me to go through them again?
I suppose.
It's a yes or no question, Ms. Hall.
I don't understand how there is still bond conditions when my bond was returned, but that's apparently something else according to my lawyer, so it is what it is.
No, I'd be happy to explain it to you. So you're on bond. So whenever you have a pending case, you are out on bond. Instead of being in custody, you're out on bond. I'm giving you a personal bond, which means you don't have to post anything, but you still have to adhere to your bond conditions. You can't go and commit a murder when you have a pending case. Does that make sense?
Alright guys, now the tension really starts to build. Alyssa questions why she still has bond conditions when her previous bond was returned. The judge, maintaining professionalism, explains that even a personal bond still comes with strict rules. But Alyssa isn't buying it. Her voice gets sharper, her tone defensive, and her confusion turns into defiance. You can see her frustration rising as she insists the bond should have been finished. The judge tries to reason with her, comparing her logic to how bond rules actually work, but she keeps pushing back. It's that classic courtroom clash, logic versus attitude. The judge is visibly trying to stay composed, but you can sense his patience slowly running thin.
So this is a new case then off of that original case, because I originally got that bond back and told that nothing further was going to happen. And then all of a sudden I was told I missed a court. So I'm still confused. Is this not the same case?
Okay, so we're going to do a full arraignment, okay, Mr. Panto?
I'm just confused.
I understand. I'm going to go through it with you. Because that's part of the arraignment, is to understand what you're being charged with. So give me 1 second. Let me
I'm
pull
being
up
charged for disorderly conduct at my brother's house. I understand that.
That's the
But
judge.
the day my bond was returned, and they sent a letter stating nothing is going to happen at this time. And then...
And I'm...
They have the right to review and file charges, which they did, and that's why we're at today's point.
All right, can we...
So they reissued the charge, and I'm reassessing a bond, which means you have bond conditions because technically you're out on bond. I'm assessing you a $1,000 personal bond, which comes with bond conditions. So I see where you would get confused if the one before got returned to you, but we're back at it. They reissued this case.
I just don't even understand how they reissued the case because it was my brother kidnapped my kids. But it is what it is. I have my own issues with Taylor Police Department and everything else right now that I'm going through. So.
Okay, well you're the one that has the case, so you're the one that has the bond conditions in the jurisdiction of this court, Ms. Hall. Do you understand your bond conditions, yes or no?
Yep. I know that my lawyer requested discovery.
I'm not talking to you. There's no question. So give me 1 second. I'm looking the report over.
Ryan Lupica is the
Is there a place?
There's an address.
That's what I'm looking for.
It's Ryan
It's
Lupica.
on Marvin Street in Taylor.
Ma'am, give me a second, okay?
This is why I hate paper.
I explained to her that the court would require she have no contact with Mr. Lupica or his address.
Yeah, I just need for the
I
bond
don't talk to
conditions.
my brother.
Ma'am,
Okay, no.
enough.
Don't talk.
Honestly, you're just digging yourself a hole right now, so just stop.
I'm not doing anything.
Ms. Hall, just, it's easy here.
Marvin Street.
Yes.
Okay. Okay, you're also to have no contact with Ryan Lupica or 13685 Marvin Street. When I say no contact, Ms. Hall, I mean no contact. That means you cannot email him, call him, or text him. That means nobody can do those things on your behalf. I see you're listening, but I don't need the attitude. You cannot send a text message, a tweet, an instant message, or anything of the like. That includes contact on Facebook, Instagram, Twitter, Cash App, or any form of electronic communication whatsoever. If you have him added on any form of social media, you are to delete him immediately. Sending a blank message is considered to be contact, since I'm instructing you to take specific steps to make sure that does not happen. If the communication comes from you or by the direction of you, it will be considered contact, and it will not be a defense that you accidentally contacted him. If he contacts you, you are not to reply. If he's at a public place, such as a store or a park, and you see him, you are to leave immediately. This is the order of the court. The victim in this case cannot change the order, only a judge can. If he were to invite you over or to ask to meet you anywhere, and you do so, that is a violation of this court's order. If we need to change this order at any point, we will have a hearing with both parties present. Do you understand that?
Now things get serious. The judge lays down the no contact order, and he does it with absolute precision. No texts, no calls, no messages, not even social media reactions. Alyssa tries to interject, but the judge doesn't budge an inch. His tone shifts from explanatory to firm authority, making it crystal clear that this is not up for debate. Every possible loophole she could think of, he shuts down on the spot. It's a masterclass in courtroom control, where one wrong word could change everything. Alyssa's body language screams annoyance, but the judge stays unshaken. By the end of it, you can feel that she's been verbally boxed in, realizing that even sarcasm won't get her anywhere here.
Daniel McGregor. Good to hear you. All right, Mr. McGregor, this is cause number CR 24172, and we're here on a status hearing regarding your hiring an attorney. Tell me where you're at on that.
Yes, sir. I had brought the paperwork that I needed to prove contingency. I brought the pay stub and the worth of my card, and right now I'm in between jobs, so I got approved for unemployment temporarily until I can get another job. I'm just waiting for those deposits to come through because sometimes they take a while to review, so currently I'm waiting for that to process.
Do you know how long that's going to take?
Usually they said about 6 weeks sometimes to receive payment, but I'm still looking at jobs, and I've got a few interviews scheduled as well. So
When are your interviews scheduled?
today and this weekend, or tomorrow.
So we've had this conversation before, and I've told you that you've applied, and I've looked at your reapplication, and you still make more money than the minimum to have a court-appointed attorney. You understand that? Because you've reported that you have zero expenses. Because didn't you say you live with your father or something? Do you live with your father?
Yeah,
He pays all your expenses.
he does.
So all the money that you make can go towards an attorney. The value of your car can be sold. It can go towards an attorney.
It's only worth $1,300.
Well, I understand, but if you've got $3,000 in benefits coming to you, you've got $1,300 in a car, and you've got no living expenses, then all you have is income and no debt. And so state law says that it's going to have to be less, that your income is going to have to be a certain level above your expenses before the court is going to be able to find you indigent. So we had this conversation last time that you may have to sell your car.
But $1,300 doesn't help me get $10,000.
Next up, we meet Daniel McGregor, a man armed with excuses instead of accountability. He insists he can't afford a lawyer, but the judge immediately pokes holes in his story. Daniel admits he has a car worth $1,300, unemployment benefits on the way, and zero living expenses since he stays with his dad. The judge quickly calls out the contradictions, sarcastically asking what kind of hillbilly math Daniel's doing. His tone is cutting but fair, exposing how Daniel's reasoning falls apart. This isn't just about money, it's about priorities, and Daniel clearly hasn't got his in order. Watching the judge methodically dismantle his excuses is both satisfying and painful to witness. The tension is thick, and the warning signs of what's to come are already flashing.
It doesn't. It helps you. It would help me get $10,000, because that's $1,300 towards that $10,000.
They haven't released the funds at all, and they're basically still reviewing. And the only money I had was the $111 from Abby's Bagels. So that didn't last very long because I asked them questions about their policy, and they said that it wasn't working out. So
How much are you paying your bondsman?
paying what?
How much are you paying your bondsman?
The bondsman, I paid $5,000 total, but that was when I had a job. HEB supplied my ability to pay. That went away because they took hours away, and I was driving too far. So I've been kind of up and down with jobs. Like, I've had 3 jobs the past year, and none of them have worked out very well. Just due to scheduling of new employees and overstaffing, things like that.
All right, Mr. McGregor, I'm going to reset you for 2 weeks. I want you back here on October 17th. You come back and you still have a car and you still have income and you have no expenses, and you come back without a lawyer, we're going to have a hearing on your bond. I may find your bond insufficient that day, and I may put you back in jail. The longer you sit in jail, more likely you're going to become indigent to the point where I can appoint you an attorney. You see how that works? If you're going to pay your bondsman $5,000, you're going to have a job, you're going to pay them $5,000, and you're going to get out of jail, but you're not going to hire an attorney to go forward on your case.
I would hire an attorney if I had $10,000 to come up with, but it's just not possible for me.
You've got a car and you're unemployed, right? So you've got a car, so you could drive to all these different places that are all looking for people to hire, right? Sounds like it's possible to me. So I want to see you back here in 2 weeks. If you don't have a lawyer in 2 weeks, then we're going to discuss your bond that day.
And now, the explosion. As Daniel leaves the courtroom, something in his behavior immediately catches the judge's attention. Within seconds, he's called back, and the tone in the room shifts from calm to commanding. The judge declares his bond insufficient and orders him into custody right there on the spot. The room goes silent as Daniel protests, realizing too late that his attitude has backfired. The judge ups his bond to a staggering $150,000 and even threatens him with 6 months in jail for contempt. Daniel's arrogance melts into desperation as he apologizes, knowing there's no way out now. It's a perfect example of how quickly things can spiral in court when you test the judge's authority. If you enjoyed these wild courtroom moments, don't forget to like the video, subscribe to the channel, and we'll see you in the next one.
Bring it back in here when you get a chance, Fabio. Oh, yeah. Mr. McGregor, you've just disrupted court with your behavior today and your actions. You understand that?
I accidentally tried to open it the wrong way. I apologize.
I'm going to find your bond insufficient today. Deputy Martinez, go ahead and take him into custody. Mr. McGregor, I'm going to appoint you an attorney.
So I might as well have stayed in jail, basically.
But you're going to jail now, and I'm going to up your bail to $150,000, and I'm going to appoint you an attorney.
150,000.
Yeah, that's what I said. 150,000, $150,000.
For opening the door the wrong way?
No, not for opening the door the wrong way. Do you want me to hold you in direct criminal contempt and sentence you to 6 months in jail, day for day, on top of a child charge that you have? Do you want that? Yes or no? No? Okay.
I apologize.
So good. Well, it's done. What's done is done. You'll learn your lesson, I hope. All right. Go ahead and take him, and I'll send over an order.